Okay, Ms. Harris, thank you for returning for closing. Are you ready to proceed?
I am, Your Honor, and as a preliminary matter, I'd like to provide you with the book of authorities for the plaintiff. I have already provided it to my friend, Mr. Harani, well in advance of today's date.
Thank you.
And I will be using these cases in my closing to highlight my submissions on the law.
Thank you so much. Whenever you're ready.
Your Honor, it's our submission that John Jones has been unjustly enriched by the actions of Fred Freeman. As a result, we submit that a constructive trust should be imposed and that Mr. Jones be ordered to compensate Mr. Freeman for the sum of $100,000. That includes the sum of $65,000 for the renovations for the home, the $25,000 for the vehicle refurbishing business, and the $10,000 for the engagement ring. I'm going to address the home renovation and the car refurbishing business under the law of unjust enrichment and the constructive trust, and I'll be addressing the engagement ring as a separate submission under the gift heading. First, I will do an overview of the evidence, and finally, I will address a limitations issue, which has recently come to my attention. Mr. Freeman testified. He told us that he's a 40-year-old computer engineer from Brandon, Manitoba. He met Tanya Turner via the internet in August of year -1. At the time, Tanya Turner was a resident of Dorchester, Ontario. It was a long-distance relationship. That relationship burgeoned and solidified to the point in September of year -1 when Mr. Freeman began to invest in his future with Tanya Turner. That began with a $25,000 investment in a car refurbishing business. In December of year -1, Mr. Freeman purchased a custom designed ring, diamond encrusted replica of the Galadriel ring from the Lord of the Rings, and that engagement ring cost him $10,000. You've seen the receipt, Your Honor. In February of year, Mr. Freeman traveled to Dorchester to finally meet Tanya Turner in person. At that time, he proposed to her. That proposal was accepted. He also confirmed that Tanya Turner had indeed purchased a 1968 Mustang for the price of $8,000 and was planning on beginning refurbishing it for sale at a later date. At that time, they also solidified their plans for their future. They had decided that upon his return to Brandon, Manitoba, Mr. Freeman would give notice at his job and then start making arrangements for his permanent move to the Dorchester property. As part of that, the property in Dorchester had to be renovated. And upon his return to Brandon, Manitoba, Mr. Freeman transferred $65,000 to Ms. Turner for the purposes of renovating the home. He also gave his notice at work and began to make his plans for his move and his life with Tanya Turner. Unfortunately, in June of year, Tanya Turner was struck by lightning and was killed. On June 30th of year, Mr. Freeman attended her funeral. After making a permanent move to Ontario, he arrived at the Dorchester property expecting a home and was welcomed by changed locks. He conducted a title search of the property and discovered that John Jones was the surviving owner of that property. Since that time, he has not been permitted onto the Dorchester property. He has not seen the ring that he had given Ms. Tanya Turner as an engagement ring. And he has no idea of where the $100,000 has gone. You also heard from Mr. John Jones. He met Tanya in year -10. They also married that same year. They bought the Dorchester home with Tanya Turner's inheritance from her uncle in year -7. He lived at the Dorchester property for approximately 3 months. At that time, they separated. And at the time of the separation, he testified that he offered to remove himself from the title of that property. That offer was not taken up at that time, and he moved back to London. There was no separation agreement, no spousal support, In year -1, John Jones became aware that Tanya was dating again. In year, she revealed to him that she was engaged to be married, had started a car business, and that her fiance from Brandon, Manitoba, was making a move to the Dorchester property. Tanya asked him at that time if they could remove his name from the property register. He agreed. Unfortunately, Tanya died before that could happen. After Tanya Turner's death, John Jones moved into the Dorchester property, put the 1968 Mustang in the garage, pawned Tanya Turner's engagement ring for what a pawnbroker said was a fair price of $1,000, and halted a $65,000 renovation in midstream without a refund because he could do the work himself. Your Honor, those are the facts as I understand them. If you have any questions, I would welcome them.
Not at this point. Thank you.
Okay. Turning now to the law, I'll begin with unjust enrichment. Located at tab 1 of the Plaintiff's Book of Authorities is the case of Peckus and Becker. It's a 1980 case from the Supreme Court of Canada, and it lays out the elements of unjust enrichment at paragraph 38. The elements of unjust enrichment, Your Honor, as enumerated by this case, are enrichment to the defendant, a corresponding deprivation to the plaintiff, and an absence of any juristic reason for the enrichment. Now, I would submit to you that Mr. Jones has been enriched by the investment of money by Mr. Freeman in Tanya Turner's home and business. He has the benefit of the $65,000 that Mr. Freeman invested in the renovations. The renovations were halted midstream. However, any renovations that were completed with Mr. Freeman's money, and it was Mr. Jones's choice to stop the renovations, which had been fully paid for. It was the testimony of Mr. Jones that $65,000 had indeed been paid to the contractor to complete the work, and that as the renovations were canceled, there would be no refund from the contractor. And Mr. Jones did not pursue that with the contractor himself. So it's my submission, Your Honor, that Mr. Jones has the benefit of the full $65,000.
I guess I have a question about that because it seems that only part of the renovations were completed. And I get that there could be some benefit from that. And what you're suggesting is his failure to pursue the balance from these builders or the renovators, that too is a form of benefit to him. And it kind of hinges at least on his unwillingness to go after the balance from these folks.
That is my submission, Your Honor. It's my understanding that the remaining balance would actually be a cause of action for Mr. Jones in and of itself. He could pursue the contractor for the remaining monies on the renovations. And it was through his own actions that he didn't get the full benefit of the $65,000. And it's also through his own actions that he hasn't pursued the balance on them or the balance owing. And it's my submission that Mr. Freeman should not be penalized for the fact that he's invested $65,000 and paid $65,000, and that it was the actions of a third party, Mr. Jones, who have completely negated the benefit for him.
Okay. Thank you.
With respect to the motor vehicle refurbishing business, Mr. Freeman invested $25,000 in a car refurbishing business. We know that $8,000, or there's evidence that there was $8,000 spent on a 1968 Mustang. And there was some evidence to suggest that Ms. Turner had done some work on the garage and had plans to buy parts and various machinery to help her in the refurbishing business. So it would be also my submission, Your Honor, that the car, any machinery bought and any improvements to the garage, which is on the property of the Dorchester property, would also be an unjust enrichment to Mr. Jones.
You'll have to agree with me, Council, that there's probably some evidence of $8,000 worth of investment in this business, but the balance, there hasn't been a lot of evidence as to what the remaining $17,000 really went for. Is that fair to say?
That is fair to say, Your Honor, and if as fact you find that only $8,000 was invested in the car refurbishing business, I would ask you to find that it was in fact Mr. Freeman's $8,000 and that that should form part of the constructive trust.
Thank you.
Those are my submissions on enrichment to the defendant, and I'll turn now to deprivation to the plaintiff. I would submit that Mr. Freeman has in fact been deprived of the complete benefit of the $65,000 for the renovations and the $8,000 to $25,000 for the car refurbishing business. With respect to the home renovations, he has not been allowed on the property. It's unlikely, as Mr. Jones was the remaining title owner, that he will ever be allowed on the property to enjoy the fruits of the $65,000 that he paid for the renovations. He had no say in when those renovations would be canceled or completed, and none of his money has been refunded to him by either the construction company or by Mr. Jones. And that's a complete deprivation in my submission, Your Honor. With respect to the car refurbishing business, whether you find that it's an $8,000 deprivation or a $25,000 deprivation, the same applies. Mr. Jones has parked the Mustang in a locked garage, and Mr. Freeman has absolutely no access to it. There has been a deprivation and a complete deprivation of that money to Mr. Freeman as well. And to the final point that there's any juristic reason for the enrichment, it would be my submission that there is no reason in law why Mr. Jones should be so enriched by Mr. Freeman's investment in a future relationship. This money was money that he put into his future with Tanya Turner and himself. And Mr. Jones was an absolute stranger to that relationship. And it's my submission that as a result, there's no legal reason and there's no reason in equity that Mr. Jones should have the benefit of the $65,000 for the renovations and the $8,000 to $25,000 for the car refurbishing business.
Thank you.
Turning now to the remedy or the law of constructive trust. The remedy for the unjust enrichment is for the court to impose a constructive trust. This is what happened in the case of Peckus and Becker. You can see that at paragraph 102, that a constructive trust was imposed. And a constructive trust it's not an implied term of any contract, and it's not an express term of any relationship, but it's imposed by the court as an equitable remedy where one party has come by a benefit from another party, either unintentionally or unjustly. And I would submit that in this case, that's what happened. Mr. Jones, although his actions with the ring come under question, he hasn't been dishonest in his dealings with the property. It was in fact his property, and he did not realize that Mr. Freeman had invested so much in it. So it was unintentional on Mr. Jones's part, but the fact remains that that relationship, to be equitable to Mr. Freeman, could be imposed by the court. And the cases that I would like to turn your attention to, the first one is Taylor and Davies. It's a 1917 case. It's located at tab 2 of the Plaintiff's Book of Authorities. Paragraph 26, the court stated that a constructive trust, apart from a resulting trust, may be defined as one which is not expressed in any instrument, but is imposed upon a person by a court of equity upon the ground of public policy, so as to prevent him from holding for his own benefit an advantage which he has gained by reason of some fiduciary relation subsisting between him and others, and for whose benefit only it is his duty to act. It's also explained in the case of Rathwell and Rathwell from 1978. This is a Canadian Supreme Court of Canada case. And I would like to turn your attention to paragraph 57 of that case, Your Honor.
Which tab are we referring to?
Tab 3, Your Honor. I apologize.
Thank you.
And in that case, the Supreme Court of Canada has stated that the constructive trust, as so envisioned, comprehends the imposition of trust machinery by the court in order to achieve a result consonant with good conscience. As a matter of principle, the court will not allow any man unjustly to appropriate to himself the value earned by the labors of another. That principle is not defeated by the existence of a matrimonial relationship between the parties, but for the principle to succeed, the facts must display an enrichment, a corresponding deprivation, and the absence of any juristic reason, such as a contract or disposition of law, for the enrichment. And I would submit to you, Your Honor, that in this case, the facts show that Mr. Jones has the benefit of a significant amount of money from Mr. Freeman, and that there is no reason at law for that enrichment to continue. Subject to questions on the constructive trust law, Your Honor, I'd like to turn to my analysis of the engagement ring.
I do have one question, just so I'm clear on the amounts. If I was to find that the appropriate remedy on this part was a constructive trust, depending on the values that we go with, it could range from $73,000 at the lower end to $90,000 at the high end. Am I in the right ballpark, Ms. Harris?
Yes, Your Honor. It's the $65,000 from the home renovations, and the car refurbishing business is what is causing the difficulty. We know that the value of the vehicle purchase was $8,000, and it's the remaining $17,000, which I would submit for my client that there is evidence to suggest that it was used in the car refurbishing business, but it's at Your Honor's discretion to look at the facts and the evidence as entered to decide exactly how much Mr. Freeman should be compensated.
All right. Thank you.
Turning now to the engagement ring, the major issue at this juncture is whether or not the ring was an outright gift. I would submit, Your Honor, that there are 3 elements of a gift between parties, and this is from Professor Bruce Welling's book, Property in Things, at page 58, and I have reproduced his writings at tab 4 of the Plaintiff's Book of Authorities. And there are 3 elements of a gift, Your Honor: donor intent, delivery of the gift, and acceptance by the donor. It's our submission that the issue in this scenario is donor intent. A gift must be a gift without conditions for it to fall under the definition of gift. The ring was a gift in contemplation of something. A condition had to be fulfilled. And that condition was that Tanya Turner had to say yes. She had to agree to get the ring. She had to agree to marry Mr. Freeman. I would like to turn your attention to the case of Robertson v. Cummins, which is at tab 5 of the Plaintiff's Book of Authorities, specifically paragraph 17. It is a case from 1742, Your Honor, but it is a case with some authority.
1742, counsel?
It is a case with the authority behind it, Your Honor, and it has not been overturned. That case states, if a person has made his addresses to a lady for some time, upon a view of marriage, and upon a reasonable expectation of success, makes presents to a considerable value, and she thinks it proper to deceive him afterwards, it is very right that the presents themselves should be returned, or the value of them allowed to him. In this case, there is no suggestion that Tanya Turner deceived Mr. Freeman, but unfortunately, she died before the condition could be fulfilled. And it would be my submission that as that condition of marriage was not fulfilled, that the ring should revert, as this case states, back to Mr. Freeman. I would also turn your attention to tab 6 of the Plaintiff's Book of Authorities, which is the case of the Township of Metcalfe and the Townships of Adelaide and Warwick. This is a 1901 case, a little more recent. And at paragraph 25, the court has stated that a present made in prospect of marriage may be revoked or demanded back if the marriage does not take effect, especially if it sticks on the side to whom the present is made. In this case, the gift of the ring was made to Tanya Turner. Her death meant the marriage could not be fulfilled. It's my submission that based on the case law, that a gift in contemplation of marriage, if the marriage is not completed, should revert back to the giver, in this case, Mr. Freeman. Unfortunately, the ring is no longer available. It was pawned by Mr. Jones for $1,000, even though Mr. Freeman has evidence that the value of the ring is $10,000. So it's our submission that Mr. Freeman, not being able to get the ring back at this juncture, should be compensated for the value of the ring. And the value of the ring being what he invested in its purchase. So we would request that Mr. Freeman be compensated for the amount of $10,000 with respect to the ring, Your Honor. And those are my submissions with respect to the engagement ring. Subject to any questions, I'd like to turn to a limitation period issue.
Certainly.
Okay. Section 4 of the Limitations Act, which is which is reproduced at tab 7 of the Plaintiff's Book of Authorities, states that a proceeding must commence prior to the second anniversary of the discovery of a claim. I would submit, Your Honor, that the important and pivotal word of that is the discovery of a claim. And discovery is defined in Section 5 of the same Act. And it's defined as a claim is discovered on the day in which the person with the claim discovered or first knew of the injury, loss, or damage. In this case, Tanya Turner died on June 1st of year. Her funeral was held sometime later on June 30th of year. It was at that time that Mr. Freeman discovered that he was not going to get the benefit of the home in Dorchester or the car renovation business, and that his engagement ring to Ms. Turner was not going to be returned. So it's our submission that the discoverability of Mr. Freeman's claim was, in fact, June 30th of year. You'll note that Mr. Freeman filed his claim on June 20th of year +2. So in our submission, he has indeed met the limitation period, and his claim should be permitted to move forward as such. In conclusion, Your Honor, we are requesting an order finding that Mr. Jones was unjustly enriched by Mr. Freeman, and that a constructive trust resulted in the sum of between $73,000 and $90,000 for the renovations to the home and the car refurbishing business, and in the sum of $10,000 for the engagement ring. And we are requesting a total compensation of between $73,000 and $100,000. Excuse me, we are requesting compensation in the range of $83,000 to $100,000, Your Honor.
Okay.
Subject to your questions, Your Honor, those are my submissions.
I do have one question. To look at all the evidence again, but if in fact Ms. Turner's own unilateral actions around some of this money caused it to not benefit